The hearing is in the matter of case number CF 5070-2022 before His Excellency Deputy Chief Justice Ali Madhani. The claimant is represented by KBH and the lead counsel is Ms. Bushra Ahmed. The defendant is represented by Clyde & Co. and the lead counsel is Mohin Hinder Pal Sethi KC. Thank you very much.
Yes, good morning. We are here today to hear your contest of jurisdiction application, Mr. Sethi, on behalf of the defendant. Is that right?
That's correct, Your Excellency.
Yes, I'm aware of your submission. I've gone through the submission from the case document as well, and I've seen Ms. Ahmed notes that put before me this morning, which is it's kind of unusual note to be put in that way, but well, I mean, we have to deal with it. I mean, Ms. Ahmed, you don't want to raise it as a housekeeping issue, I guess it's not, because it is. I think it touched the core of this contest of jurisdiction application. It's more like a legal theory. You're not happy with the criteria that's taken by the defendant, but if you would like to take any advantages of the criteria, you may do so during your time to speak. Is that right?
Well, Your Excellency, in my skeleton argument that was served on the 13th of March, paragraphs 2 and 3, I identified that it was difficult to see the legal basis upon which my learned friend was bringing his jurisdiction contest, and therefore I reserved the right to file a supplemental submissions. When we received my learned friend's skeleton argument, it appeared that he was putting forward a proposition that the court ought to take into account a merits test, and it was only in relation to that we filed the note. But Your Excellency, I'm more than happy to take Your Excellency through that note if that assists.
I see. I think in your time, maybe we'll turn to Mrs. Sethi. Am I pronouncing your name correctly, Mrs. Sethi?
Your Excellency, thank you very much for inquiring. Yes, it's Mr. Sethi.
Yes, Sethi. Yes.
I'm grateful.
Lovely. So yeah, I would. You might see the difficulty Ms. Ahmed is trying to put is there is I mean like kind of she's trying to introduce or attack your jurisdiction application from that basis. Where are you going? Are you pleading you are the wrong party, or are you contesting jurisdiction, or somewhere in a gray area from that? So I will allow you to start the way you prefer, but I'm sure you will be covering all of these things.
I will indeed, Your Excellency. May I? You've indicated that you've read the skeletons. May I just begin then by assuming that you are cognizant of all the relevant key facts? Obviously, I'll take you through those.
Yes, please.
But just at the outset, it's probably worthwhile spelling out how it is that where the parties now stand.
Right.
So the claimant's only claim is for breach of an employment contract with the defendant.
Yes.
That is clear from the particulars of claim at paragraphs 40 to 49.
Right. So breach of contract, employment contract.
Yes, and it suggested
a verbal contract.
Yes, the case for the claimant is an express oral employment contract with the defendant, reached on the 7th of July 2021.
I'm aware of that. Yes,
I'm grateful. So that is the case that the claimant brings, and the claimant's case is that he entered this employment contract. Whilst he seeks to rely in these proceedings on that employment contract he alleges to have entered into with the defendant, if one looks at his pleaded case, the pleaded case is that he entered an employment contract with Liberty DMCC in September of 2019. And so one sees that if one goes immediately to paragraph 6 of the particulars of claim, and this is quite a critical and important point, he says on the 6th of September 2019, this is at page 10 of section 1 of the case lines file, on or about 6 September 2019, the claimant entered into an agreement with Liberty DMCC. Do you see that?
Yes.
So his own case is he entered into an agreement with Liberty DMCC to provide his services from on or about 1 January 2020 as its Chief Executive Officer, Global Primary Steel and Integrated Mining. And the claimant says these are the terms of employment on which he was employed. And he says the terms of employment were set out in a letter dated the 5th of September, which you will have seen, the original offer letter, sent to the claimant by email on the 6th of September. So the claimant's case, the claimant's starting point is he was employed under a contract of employment by Liberty DMCC as its Chief Executive Officer from the 1st of January 2020 by virtue of a 6 September 2019 contract. That's his case. And we agree with him. And this is important because I may as well cut to the chase on this point, Your Excellency. One also needs to look at Kahlon 1, paragraph 6.1. And that is at page, section 2, page 16. Does it help, Your Excellency, if I give you the page numbers in this fashion, section followed by page number?
Yeah, or you can even refer to me from this system, whatever you can. Yeah.
Yes, so within case lines, it's section 2, page 16. So to confirm his pleaded case that I took you to, his evidence before you today is at 6.1 of his first witness statement. On or about the 6th of September, I agreed terms of employment with Liberty FE Trade DMCC, Liberty DMCC, to provide my services as its global CEO, Primary Steel, the employment terms. So his pleaded case and his evidential case is squarely that he commenced employment pursuant to an employment contract with Liberty FE Trade DMCC on or about the 6th of September by virtue of his so-called employment terms found in the original offer letter. Now, Your Excellency, if I could take you to the claimant's skeleton for today.
Yes.
And if I could take you briefly to paragraph 53, please, if I may.
53.
Paragraph 53 on page 13.
Yes, at the top of the page, yes.
And can I direct you to the last sentence of paragraph 53, where my learned friend submits to you today, in the light of what I've shown you about her pleaded and evidential case. The arrangement was, she says, that he would be paid by Liberty DMCC, even though he was not employed by Liberty DMCC, and there was no contract of employment between the claimant and Liberty DMCC. I start with this, Your Excellency, because this is clearly an important case for all parties. But it's of the fundamental essence of this dispute that one, particularly in a jurisdiction matter, at the very least, one needs to be consistent with the pleaded case and the evidence presented in support of it. What paragraph 53 of my learned friend Skeleton purports to do, and this is the basis of her submissions throughout, she says, never an employment contract, never with Liberty DMCC. Your Excellency, with respect, that flies in the face of her own pleaded case and her own evidence. That is an important factor for me to respectfully highlight at the outset. So her submission is contrary to her pleaded and evidenced case. Now, paragraph 9 of the alleged, of the particulars of claim, I could just take you back to that. to see how the claim is pleaded. Paragraph 9 alleges that there was an oral agreement on the 7th of July 2021 that the defendant would be bound by the terms agreed with Liberty DMCC. So I took you to paragraph 6 earlier, which is the original contract with Liberty DMCC, and it suggested that the nature of the oral agreement was that on or about 7 July, and on a number of occasions thereafter, although that's not pleaded or evidence, Mr. Gupta, on behalf of the defendant, orally agreed that the parties would be bound by the terms of employment. Paragraph 10 and 11 appear to be needing to be taken together, because it is suggested that if you're not with the claimant on there being a express oral agreement on the 7th of July, that there was some implied novation, because it was the expectation or intention of the parties at paragraph 10, or that the conduct of the parties at paragraph 11 evidences or infers an agreement that the claimant would be employed by the defendant. The defendant's position is that there never was any contract between the claimant and the defendant. Any contract was with Liberty DMCC, and that was, when we're talking about a contract, obviously we're talking about an employment contract. And Liberty DMCC, of course, is a body which was and is licensed by the DMCC to operate in the Jumeirah Lakes Towers free zone. The next point it is important to identify at the outset, when we're scoping the nature of this hearing, is that it is clear from the claimant's skeleton now that the issues are more refined than before skeleton arguments were exchanged, because the claimant at paragraph 61, if I may take you to that, paragraph 61 of the claimant skeleton, in the claimant's skeleton argument,
Yeah, page 6.
paragraph 61 at the top of the page, it is said that, second sentence, the DMCC contract is not the contract pursuant to which the claim is being brought. This is a different contract against a different establishment. The claimant is pursuing a claim pursuant to the DIFC contract against the defendant, a DIFC establishment. The governing law clause would only be relevant if the claim was being pursued against Liberty DMCC, it is not. So this is a very important point too. There is no, it is clear from the claimant skeleton that the claimant does not bring any claim against Liberty DMCC. So in these circumstances that we're now faced with, the question that the court has to determine today is the following. Firstly, has the claimant established a good arguable case that there is a contract between the claimant and the defendant? If the claimant establishes that there is a plausible evidential basis for a good arguable case of an employment contract between the claimant and the defendant, then jurisdiction is established under Gateway A, because the defendant accepts that it is a licensed DIFC establishment. But the important point, the real, and this is essentially what today's hearing will be about, no doubt, that issue breaks down into two further questions. The first is, was there a binding oral agreement expressly reached that the defendant would be bound by the terms of the claimant's contract with Liberty DMCC. If there was, and the second sub-question is, if there was not an express oral agreement that defendant would, that there would be a transfer of employment from Liberty DMCC to Liberty DIFC, can the court infer from the parties' conduct that there was a novation of the contract with Liberty DMCC to the defendant? So is there an express oral agreement to novate, or secondly, is there a implied agreement to novate? If there was no contract with the defendant, that is the end of the matter. There are no claims, no other claims being pursued, as I identified a moment ago. In our skeleton argument, when we addressed particularly the gateways B and C, we assumed that the claim was brought, or maybe sought to be brought, in the alternative against Liberty DMCC. But of course, the claimant has now disavowed and abandoned any such suggestion, as you can see from paragraph 61 of her skeleton, no claim against Liberty DMCC. Also, it is clear that the claim cannot proceed in any event against Liberty DMCC. There would be no basis to seek a penalty payment, etc., under the Employment Act, Employment Law, number 2 of 2019, because Liberty DMCC is not operating in the DIFC. As you know, Article 4.1 of that law provides that it applies to an individual employed by an employment contract with a person having a place of business in the DIFC. So Liberty DMCC does not have a place of business in the DIFC. So the question of jurisdiction, therefore, lives or dies with the existence of a contract to transfer the claimant's employment from Liberty DMCC to the defendant. It is one thing to seek to try to just infer a contract of employment between two parties where there isn't a previous relationship. It is quite a different thing to find either an express or implied agreement to novate, to move, to transfer the employment from one employer to another. In short, we say that has to have extremely clear terms. It has to be unambiguous as to its time for performance. In other words, this is the case where there is, one understands why the claimant doesn't wish to highlight the fact that there's already a pre-existing employment contract with the DMCC, because it makes the ability to argue a novation much more difficult. If you didn't have any relationship beforehand, then you might be able to argue that there's some relationship of employment is formed between the claimant and the defendant. But where the claimant is already in a pre-existing relationship with Liberty DMCC, the claimant has to put forward a plausible evidential basis for a good arguable case that there was a fundamental transfer of employment contract, that Liberty DMCC, the contract with them terminated, and that the employment contract, as it were, transferred, and that the identity of his employer changed. And the claimant says that this happened on the 7th of July by virtue of some oral agreement, he says, expressly reached and clearly reached, he says, with Mr. Gupta. There is an interesting, we say, argument that my learned friend raises. Her additional note is to the point, where it is submitted by the claimant that so long as the defendant is a licensed DIFC establishment, and that is a question of record, we've got nothing to argue about today. That's the end of the matter. She says, you get by on gateway A, and there's no way you can challenge jurisdiction. The difficulty with that is it's an argument. It's a basic argument. We say it's an ambitious argument because you cannot ignore the claim that is being made by the claimant, and that's why I started my submission today with identification of what the claim is. The claim is for damages and other remedies for breach of an alleged employment contract with the defendant. So it is not sufficient simply to identify a party which is a licensed DIFC establishment. You've got to identify the cause of action with that licensed DIFC establishment. Otherwise, on my learned friend's case, and it does appear to be this stark, anyone can bring a claim against any DIFC licensed establishment because they name them as the defendant on a claim form. And the court assumes jurisdiction, regardless of whether or not there is actually a contract in existence to form the basis of any claim against that licensed DIFC establishment. That is an incredible, and we say ambitious submission to make. And we say that clearly, respectfully, is not the legal position. It can't be. We have authorities for this, which I'll take you to, Your Excellency, in due course. And perhaps I'll address you on when I deal with Gateway A. I'll deal with that point head on.
Right, I'll be waiting for it. Yes.
Thank you. Can I then just go back then a stage? So, in my skeleton argument, because of the way in which the claimant has clarified that there's no claim against the DMCC entity, in a sense, Gateway B and C might be academic, because she just needs to establish a contract with a licensed DIFC establishment. All three gateways, I should add, turn on the existence, the formation of a employment contract between the claimant and the defendant DIFC establishment. So in a sense, that is really the issue today. Has a claimant made out a good evidential basis, good arguable case for that contract? So if we go back to the facts of the matter, the defendant is part of the Liberty Steel Group, and as I say, it's a license by the DIFC. The claimant is, as I've said in the skeleton, a highly successful, highly experienced, mature, sophisticated commercial businessman and individual executive. He is not a low-level employee who does not have the level of sophistication of engaging in commercial dealings. His own description is that he is among the world's top global steel executives. So all parties agree that the claimant commenced employment in around January of 2020 with Liberty DMCC. And I say all parties agree, I mean, other than the claimant skeleton, certainly the claimant's pleaded case and evidence case is that he commenced employment with Liberty DMCC in or around January 2020. Now, it is important to note that all of the contemporaneous documentation points to a contractual relationship between the claimant and Liberty DMCC. No contemporaneous documentation or contractual nature points at all to a contractual relationship between the claimant and Liberty DIFC. All we have are some is the claimant's account in his witness statement of the 7th of July meeting. So what do we have? Firstly, one looks to the offer letter dated the 5th of September 2019. If I could take you to that, Your Excellency, at section 3, page 6. Do you have that?
Not yet. 1 sec. I'm trying to find it again. What it is where did you refer to?
Section 3, page 6 of the case lines file. Section 3 is the exhibit section. So it's 3-6. Do you have that, Your Excellency?
Yeah, I do. I don't know. I think the application is giving me different now. Show me different orders.
Difficulty on Teams is that we don't see what you're seeing. What do you see at that page?
With section 3 now, I can see only the claim form. It's page 1.
You're within section 1, pleadings.
Yeah, but the rest is disappeared.
Oh.
Yeah, I don't know. I can't see it. I only can see the bleeding now. And nothing beyond the bleeding. There is 6 subsection under section 1, the bleeding. And the final document now in my screen is the consent order. And it was just there. I don't know where it's gone. Let me refresh this. If you bear with me, please.
Yes, of course.
Nope. Hamad? Hamad? Are you with us?
Yes.
Hamad, can you log on to this case and check whether the case line is, the e-bundle is complete with you? Can you see it complete? I don't see it. I just see bleeding only.
So
Yeah,
I
what
have
do you
nine
what do you see?
sections.
You have
I
9
have-
sections.
Yes.
Oh, that's weird because until yesterday I have them all. I don't know, it just disappeared.
Do you see where it says on the left, it says 01 master bundle? Above number 1 where it says pleadings, there's a little tab that says change. It's in blue.
No, I don't have it. I don't have the change. I have only application bundle.
Patient bundles.
Yeah.
Because, you have to
No,
change it.
no. Yeah, tell me.
And do you want me to come to your office and see?
If you would like, yes.
Yes.
Come in, hand. See, that's the bundle, okay. That's what I have. You see what I see?
It doesn't say change there.
No, you see, it's not here.
You close it and open it.
I will close it and reopen it again. Okay, sure. Over here. It's the same.
It's the same.
Well,
I'll speak to adjust.
that's a technical problem, but yeah, I will go on. I'm aware of that. That time issue. We have to continue, but for now, you can ask the technical team to do something. I beg your pardon. I mean, apparently I'm having small technical problem, but we should move on because I'm very conscious about the time. Yes, City. Anyway, is it in your order that you should finish within half an hour, maybe, or something like that?
No, there's no time allocations.
Oh, I thought the registry have alerted you that it's 2-hour application or short application. Anyway, when you're anticipating to finish, how long you want to go?
I would assume that I would be an hour.
For you, yeah, which we already have an hour, and yeah, you still
Yes.
need another hour.
Yes.
Okay, I would urge you if you can finish earlier.
Sorry, Your Excellency.
If you can finish earlier than an hour.
I shall try my best. Do we
Please.
have a time? Do we have a time limit, a time cutoff for the hearing today? I thought it was brought forward an hour to give us extra time.
Oh no, actually we brought it forward not to give you extra time, but because we have a prayer time at Dubai.
I see.
So it's Friday is a major prayer time. That's why it's. But we can have like maybe we can utilize the half an hour of that, an extra hour. But yeah. Do your best. Do your best anyway. Yeah, just give me the reference. I put it down and I go back to it. Yeah.
Right. Let's speed along. So all of the contemporaneous documentation supports the existence of an employment contract throughout the relevant period of time with Liberty DMCC.
Yep.
Even after the 7th of July 2021. And you have it's pages 6 to 7 of the bundle, you have the original offer letter. That is expressly stated to be for and on behalf of Liberty DMCC on page 7. It also expressly states that a formal contract will follow, but it sets out a few headline terms, including that the location would be the Dubai office. And at that time, the DIFC office did not exist. The Dubai office would be the DMCC office. And this occurred over a year and a half before the DIFC office was even opened.
I see.
Then what we see is that a draft contract was sent to the claimant on the 21st of May 2020 on behalf of Liberty DMCC again, albeit that was not signed by the claimant. That's at page 22 of the exhibit bundle. Then what we know is that a contract of employment dated the 1st of August 2020 was signed by the claimant and Liberty DMCC on the 1st of September 2020. That's the so-called August 2020 contract. Page 33.
Yes.
That provided that Liberty DMCC's office at Jumeirah Lakes Towers was the claimant's normal place of work, and that his employment was governed by the UAE labour law. That, as I say, is at page 33. And that contract had a number of, now bearing in mind that the claimant signed the original 5 September letter. He also signed the August 2020 contract. This is important because signature to contracts is not to be taken lightly in this or other jurisdictions. And if one looks at the August 2020 signed contract, we see that it's confined, the territory is identified as Jumeirah Lakes Towers. As I say, UAE federal law applies. It's made clear that the employment is at Liberty DMCC's offices in the DMCC. We see also at clause 1.3, this is the point perhaps that's not sufficiently highlighted, Your Excellency, in the submissions, but clause 1.3 of the August 2020 contract says that the employee shall not, during the period of his or her employment, work outside the territory or for another person, whether an individual or a corporate entity, either in the territory or otherwise, except with a prior written approval from the employer and any concerned authority. So you had an express term which says that you're not going to work outside of the DMCC for any other person or entity, except with a prior written approval of Liberty DMCC and any concerned authority, in other words, a DMCC authority. That's an important express clause that the claimant signed up to. Clause 1.3, it's page 35. The other point to note in that August 2020 contract is that there is an entire agreement clause at clause 7.1 on page 44. And that reads that this contract, together with any other contractual documentation relating to the employee's employment with the employer, i.e. with DMCC, signed by both parties and submitted to the DMCC, represents the full and final agreement of the parties with respect to the terms of employment. So this contract, when it was entered into and signed by the claimant on the 1st of September, represents the full and final agreement of the parties with respect to the terms of employment, quote unquote. And it supersedes any other oral or written representations or agreements unless such representations or agreements have been approved and attested by DMCC. So the variations to that need to be attested by the DMCC expressly. And that's clause 7.1 on page 44. There is also on page 44 a governing law clause, and it is a non-DIFC governing law clause at clause 9.1, which says that the contract and any dispute or claim arising out of or in connection with it or its subject matter or formation shall be governed by and construed in accordance with the laws of the UAE as applied in the Emirate of Dubai and DMCC free zone rules and regulations as amended from time to time. So the point in short is you have a non-DIFC governing law clause. There is also at clause 9.2 a clause which expressly stipulates that any mediation of a dispute is to be conducted by the DMCC. parties agree to attempt in good faith to settle the dispute or claim by mediation administered and conducted by the DMCC or any of its authorized representatives. 9.3 also provides for a exclusive jurisdiction of the Dubai courts. It says where a dispute or claim cannot be settled by mediation, the parties irrevocably agree that the Dubai court shall have exclusive jurisdiction to settle any dispute or claim that arises out or in connection with this contract or its subject matter or formation. And we see the signature of the claimant at page 45. You recall that clause that I referred to a moment ago, 7.1, which said that this contract, together with any other contractual documentation relating to the employee's employment, signed by both parties and submitted to the DMCC, represents a full and final agreement. Well, in addition to this DMCC contract, the claimant also signed on the same day a DMCC employment contract cover sheet, which appears at page 30. And in that, on page...
By the way, I have the bundle back with me, so I'm following with you now. I'm following.
Wonderful. I'm grateful, Your Excellency.
Yes.
And on page 32, you see the statutory undertaking by the employee that he signed, the statutory undertaking, when he says, I have entered or will enter into an employment contract with the Liberty FE Trade DMCC. You see that?
Yes, I do.
The next point is that the claimant's residence visa and employment card, which was dated the 12th of October 2020, provided that his employer was Liberty DMCC. You see that at page 46 and 47.
Right.
And you see also at page 108 an electronic company employment certificate generated in April of 2022 by the DMCCA in support of the claimant's application for a golden visa, which certified that his employer had been Liberty DMCC since the 1st of August 2020 until that point in time. Do you see that, Your Excellency?
I do see it, yeah.
I'm grateful. Then the next point to note in terms of the contemporaneous records, the written records, is that all of the claimant's remuneration, all payments to the claimant were made by Liberty DMCC until his employment with Liberty DMCC was terminated. And you see that at 10 to 13 and 109, pages 10 to 13 and page 109. The next point is that when it came to terminating his employment in May of 2022, which led to this dispute, it seems, and that's a critical document at page 110. The claimant's termination.
You said 110?
110, yes.
Yeah.
Do you have that, Your Excellency?
Yes, it's document number 43, yeah? Yes.
The very start of that letter,
9th of May 2022.
9th of May 2022, it's on
Right.
It's on Liberty DMCC letterheaded paper. It is signed by Evan Allen, the regional head of HR, from whom you've got evidence in 2 witness statements. But the very beginning of that letter, the very beginning of it, this is the termination of the contractual relationship, says, I am writing on behalf of Liberty FE Trade DMCC, the company. Now, my learned friend suggests that this is on just Liberty notepaper. It's more than that. It's not just on Liberty notepaper. It doesn't matter what notepaper it's on. What does it actually say? What it says is that this communication is being written on behalf of Liberty DMCC. And it is the document which purports to bring an end to the employment contract. Now, in addition to the contemporaneous documents that I've taken you to, the key contractual documents, and those are all of those, you will, of course, have noted in your pre-reading, Your Excellency, that the recruitment process for the claimant took place entirely outside of the DIFC. The claimant doesn't contend for a moment that it was negotiated or concluded or entered into in the DIFC, this contract. It's entirely out with the DIFC. The claimant, as I say, was paid at all times by Liberty DMCC. The remuneration was paid into his Indian bank account. He was provided with furnished accommodation outside of the DIFC in Palm Jumeirah, and his role in terms of his job function involved looking after overseas foreign businesses, so clearly outside the DIFC. They're in the Czech Republic, Romania, Macedonia, Australia. The defendants then incorporated in February of 2021, and the evidence before the court is that from June of 2021 onwards, some employees did have their employments formally transferred from Liberty DMCC to that of the defendant, but not the claimant. And there was a very formal process that was undergone, and you'll have read the evidence of Mr. Allen in his second witness statement, paragraph 12.3, and that no such process was followed by the claimant, as he says in his second witness statement at paragraph 13.2. And it was in around June of 2021 that the defendant opened an office in the DIFC. Now, I won't go into the detail of the evidence because you have it in writing. You will have seen it in the skeleton arguments. But there are various references to the claimant visiting the Dubai office. But none of this evidence contradicts the fact that he continued to be contractually employed by Liberty DMCC. So the fact that he may have frequented the DIFC office, many companies have lots of different offices, but they remain employed by their contractual employer. Where is the evidence that that the identity of his employer expressly changed? Particularly,
Yeah, you say attending the DFC office is not novation of his previous contract and his. It's not engagement. It's not changing the status of his, with whom he is contracting.
correct.
That's what you're saying.
Precisely. And what the claimant has to do is to put forward a good arguable case that despite the wealth of contemporaneous contractual documentation and the evidence of the global head of HR and the regional head of HR and the people very much in charge of the contractual process for senior executives like the claimant, and the evidence of Mr. Gupta himself in response to an allegation that there was some express oral agreement to change the entire contractual relationship from one employer to another, which is not particularly, we say, sufficiently at all. But anyway, the hurdle that the claimant has to overcome is formidable. It is really very difficult indeed for the claimant to make the case out. We say that there is a contract between the claimant and of employment between the claimant and the defendant. Now, there are a number of matters of factual dispute, but they're not particularly important, we say, for the purposes of this. What you have to determine is whether there is, despite the plethora of and wealth of contemporaneous documentation pointing to the contract with DMCC, and despite the claimant's counsel saying there's never been a contract with DMCC, which we don't understand, but despite that, where is the contract that the claimant wishes to argue for with Liberty DIFC? Now, there are no contractual documentation that identify the defendant as the claimant's employer. There's simply none. As I say, at all stages paid by the defendant, no contemporaneous records or emails or communications that refer to an alleged oral agreement between the claimant and Mr. Gupta. Remember, this is a very sophisticated, mature, top senior executive. Something as important as this, no written evidence in support. The matter was not communicated to Ms. Timms, the global head of HR in charge of these matters, in charge of dealing with employment terms for senior executives, nor the regional HR, Mr. Allen. and nor was the claimant issued with a visa or residency documents reflecting any change in the identity of the employer. No process was undertaken to transfer his employment from A to B. And you've seen the evidence from Mr. Allen that that process is an involved process. The claimant, we say, may have wanted to have he may well have wanted to have his contract transferred. That can be resolved at trial. But the fact that we have to grapple with is, what's the evidence that it did? He did discuss his contractual arrangements and the identity of his employer with Ms. Timms in February of 2022, but that did not lead to any contract between the claimant and the defendant. And the oral contract allegedly reached with Mr. Gupta in July of 2021, some 8 months previously, is not ever mentioned again. No one after that date is saying, oh, but what about that agreement we reached on the 7th of July? No reference to that whatsoever. And as I say, the employment, he continues to be paid by DMCC. The contractual relationship is brought to an end then by DMCC in that letter of termination that I've taken you to. Now, let's deal with the gateways. In the claimant,
Mr. City, I have a question before you move on to the gateway. I'm sorry for interruption, and I'm not planning to change your order of presentation, but so you tell me what before you move to the gateway. I mean, and this is in reply to as well this morning's question by Ms. Ahmed. I mean, why you have taken this direction? Maybe maybe someone else could have bring, let's say, immediate judgment application saying we're the wrong party, no pleaded, no cause of action, so strike out the claim entirely. But you have chosen to go to, contest of jurisdiction instead. I mean, if you want to keep this to the end, if you prefer, you go to the gateway first and answer this next, I would accept as well. But if you covering this both, I'll leave it up to you, but I will need you to answer this.
I can answer it now.
Then, please.
I can answer it right now. Yeah. If there is no contract of employment between the claimant and the defendant, then the claimant cannot bring a claim for breach of contract against the defendant simply because the defendant is a licensed DIFC establishment, because Gateway A relies on there existing a contract. Yeah. It has to be, because that's the cause of action against that DIFC establishment. So if there is no good arguable case that there's a contract that can found an action against that DIFC establishment, then you don't just bring you can't just bring you can't bring no claim. You have to bring a claim against a DIFC establishment. If it was the law of the DIFC that you can bring no claim, but bring an action against a DIFC establishment where there's no claim, well, that would be a nonsensical position.
And you're saying claim must be a cause of action based on yes. Either contractual or tort or some other liabilities link, isn't it? That what you say?
Yes, and that's why I start off by saying, what is the cause of action here? The claimant's cause of action is for breach of a contract with a licensed DIFC establishment. And that if that contract does not exist, and there is no plausible evidential basis for that contract existing, then that is a ground to strike out, to deny jurisdiction or to order that there is no jurisdiction, because Gateway A is not met, and nor is Gateway B or C if there is no contract.
Yeah, I've seen. I mean, I'll try to give you an example, like where in some cases, I mean, people would have like a couple of alternative cause of action. You know, and there is, let's say, a regulatory breach, there is a contractual breach, and then finally, in the whole alternativeness, there is maybe a tort.
Mm.
And then that will be checked in order, because party will try to push away the liabilities by any mean. But first of all, you need to say, well, you're suing in the right jurisdiction. If you're in the right jurisdiction, if both parties are non-DIFC. So the court would check whether there is an opt-in clause, first of all, or the transaction maybe, or the alleged
Yes.
cause of action
Exactly.
been performed or concluded or something in part at least, you
Yes.
know. But as I said, I mean, there is a fine line between where you check, first of all, because the personam jurisdiction or jurisdiction in general, and then the merit of the case, because this link is causation and evidence. Merit of the these are a merit of the case. Usually, it's checked at the second stage after jurisdiction.
Well, the answer to that, Your Excellency, is quite simple. That if it was the claimant's case on Article 5A1A, the Gateway A, if the claimant is right, then why did the claimant bother to file extensive evidence about the contractual relationship being formed and existing? There would be no need to do so, no need, because they would have simply submitted some document to show that the defendant is a company licensed in the DIFC, and that's the end of it.
Well, no, it's a bit weird you saying they are filing extensive evidence, because just a couple of minutes ago you said they have no evidence at all. There is any exist of contractual relationship anyway. You know, that one thing. I mean, but that's what I mean. I would like you to answer what Ms. Ahmed said. That may be next stage, if jurisdiction found, and then maybe we can. That's another issue. She said, don't mix the merit with the jurisdictional, which is usually done in the gateway checklist basis.
Can I deal with that?
Yeah, please. Yes,
I want to deal with that, and that's what I was turning to.
And then I will let you go on with your.
No, I was turning to that anyway. That's exactly
okay,
the point I wanted to address. Gateway A.
Go on. Yes.
So, in my learned friend Skeleton, at paragraphs 39.2 and 39.3, she refers to the decisions of Corinth and Tavira. And she says in her paragraph 40, she says this, she says the DIFC's approach to jurisdiction in Gateway A has the advantage of certainty. The question of whether a party is a DIFC establishment is not open to argument. It is either is or is not, and as such, determining the issue of jurisdiction is entirely a legal question. On the other hand, she says the question of whether there is a cause of action in a claim will require a resolution of fact. It is not necessary for the court to determine that question of fact. That is to be determined at trial and not when it comes to determining jurisdiction. Now, nobody is asking the court to determine any resolution of fact now. But all that one does on a jurisdiction application or jurisdiction challenge is to determine whether there is a plausible evidential basis for a good arguable case that there is this contract. So we're not asking you to determine disputes of fact. That is always a matter for the merits assessment at a subsequent stage. I entirely agree. But on a jurisdiction challenge, you are, if there is no plausible basis for the claimant's claim, then that is that there is a contract between the claimant and the defendant. In other words, the very foundation of any cause of action. Then the claimant has no cause of action. All it has is a party in the DIFC. It has nothing more than that. And the gateways are there to ensure that there is a pleaded plausible basis for a cause of action against the DIFC establishment. Now, the claimant's submission is that the very fact that the defendant has been named to the claim is an end to the question of jurisdiction. That we say is plainly wrong. We say that is plainly wrong for these reasons. And I'm going to make four submissions in relation to this. The first is that there is no authority cited to support her proposition. The authorities referred to in her skeleton at paragraph 39 are about unrelated points. She refers to the authority of Corinth. Now, Corinth concerned claims of deceit, unlawful conspiracy, and negligence, and they were brought against the bank incorporated in England. That bank had an unincorporated branch office registered in the DIFC. The allegations in that case were related to acts of an employee of the respondent at the Dubai branch. Judge, see paragraphs 1, 5, and 6 of that authority. And I know that clearly the hearing is being recorded, so I shall give you the references so you can go back to those later if need be. That case, which is in the claimant's bundle of authorities, turned on the definition of centre establishment under the JAL in force at the time. And the key question was whether the respondent as a whole or just its DIFC branch was a centre establishment. See paragraphs 7 to 11 of that decision. It was held at paragraph 59 that a branch had no separate legal identity, and so the respondent was a centre establishment. And it concluded at paragraph 66 that the respondent and its various branches, wherever located, fell within the statutory gateway. That's not the case here, where there are different legal entities rather than branches. So DMCC and DIFC aren't branches of each other. In paragraph 83 of that judgment, in the case of Corinth, Justice Sir John Chadwick gave his ruling and said that the determinative question under the new law was whether, when reliance is placed on the fact that a party at a licensed DIFC establishment, the claim needs to be connected with or have arisen out of conduct of that entity. And the answer at paragraph 84 was no. So the authority of Corinth is not about whether the claimant has to establish a good arguable case that they have a cause of action against a DIFC licensed establishment named in the claim. So it doesn't support the claimant's proposition. That, Your Excellency, is the case of Corinth that my learned friend relies upon at tab 6 of her authorities. She also relies upon the case of Tavira. Tavira is at tab 11. That was a claim that was brought by a company incorporated in England that established a branch in the DIFC. See paragraph 2 of that authority. It therefore fell within the meaning of the first gateway following Corinth, and the court had no jurisdiction. The DIFC branch was established only after the events of the claim, and the defendants argued that Gateway A should be construed as not applying in those circumstances. See paragraphs 9 and 14. That argument was rejected at paragraphs 39 to 40. So that authority is not about whether the claimant has to establish a good arguable case that their cause of action lies against the DIFC establishment. It's about simply whether the cause of action arose beforehand. But sorry, whether the DIFC, yes, before the DIFC branch was established. So that's the first submission I make, that Corinth and Tavira do not support her proposition that you just have to name a DIFC establishment to get your foot in the door of the DIFC court for jurisdictional purposes. The second submission is this. The claimant's proposed division between questions of law and questions of fact is misconceived. Articles 5A, A, B, and C do give rise to questions of fact, including whether a contract was concluded or performed within the DIFC, or whether a transaction or incident was committed or performed in the DIFC and related to DIFC activities. And the DIFC courts are willing and able to assess on jurisdiction applications whether there is a good arguable case that the facts necessary for a statutory gateway are made out. So that's the question. Is there a good arguable case that the facts necessary for a statutory gateway are made out?
What do you think of this? What do you think the fact necessary to establish the gateway only?
The claimant must have a plausible evidential basis for a good arguable case that a contract of employment was formed, was crystallized, was concluded,
or did exist, yeah. Mm-hmm.
Did exist with the defendant DIFC establishment. That's what the claimant has to, the burden is on the claimant on this jurisdictional challenge to show that. We have shown that there was a contract and it existed with DMCC. So we have adequately discharged our legal and evidential burden of showing that a DIFC establishment did not employ the claimant. So the claimant's cause of action is misconceived. He has brought it against the wrong party. Now, the authority for the proposition I was submitting to you a moment ago, that the DIFC, this is the DIFC court's approach, is also supported by Gavin and Gaynor, which is in the claimant's authority bundle at tab 9.
So, Mr. City, you
Yes.
arguing, so the claimant burden is to establish two things, actually. There is good arguable case, there is a cause of action against a certain entity, and then that entity fall within the regime of the DIFC. So it's like a double work you're doing. So you will need to plead some merit in order to establish the causation that this is a party you're seeing based on reality, and
Yes.
then this party is got something to do with the DIFC.
Indeed.
That's how it worked for you. Your analysis, I mean.
Well, we say
Yeah.
it's inherently part of Gateway A
Yes.
that you cannot simply bring a claim against an entity. Simply, you cannot bring a non-claim against an entity licensed in the DIFC. You've got to bring a claim, and so that claim is a cause of action. And if a party disputing jurisdiction says there is no cause of action against that licensed DIFC establishment, then there is no claim against a licensed DIFC establishment, and the court would reject jurisdiction on that basis. And that is a fundamental principle of jurisdiction in most jurisdictions in which I've operated. And
So if this is the case, why do we have Gateway A and then Gateway B and C?
Because they can all deal with slightly separate matters. So, for example, Gateway B, it's not the claimant's case, but it might be that the claimant says, for example, that he was employed under a DMCC contract, but he partly performed that contract in the DIFC by attending the DIFC offices, and therefore wishes to come within the jurisdiction of the DIFC court.
Yeah, but that would keep DMCC still a defendant. He could have ring them if he could establish he got a contract with DMCC, but it's partially performed. He could have bring the DMCC company, which we already got a contract with, without engaging the current defendants in this process.
But that it would be that kind of scenario in which
and that is not a DIFC establishment. So this, and then he has to go through Gateway B or C. Yeah.
Yeah, and then he might fail under the employment law because the DMCC is not a DIFC establishment. Do you see what I mean? So he'll get through on jurisdiction on B if that was his claim, but then he'd fail because he couldn't bring the substantive cause of action under the employment law.
Yeah.
So, and then C would be, for example, classic case of C is if he's employed by whoever, but he suffers a personal injury within the DIFC. So an incident occurs within the DIFC, or it relates to a commercial transaction in the DIFC. So you can see how the three gateways can apply to very different scenarios involving someone in an employment contract.
But let me put this before you. I mean, let's say, I mean, the court would deal with this jurisdiction at same like today for today's hearing. For instance, only if the court said found jurisdiction, is it still open for you to apply for another set of defense that you're not the right party again? Or this is the end of it? So what you pleaded today is you already have in your submission. Is it open to you again to bring another defense? As well, okay, you find say jurisdiction based on because defendant is the DIFC establishment, and then another set of defense is available for you. Maybe you say, well, I'm the wrong party anyway. There is no cause of action. Are you allowed to re-argue that matter again after the jurisdiction is concluded?
I believe I understand the question that Your Excellency has understandably posed. The short answer is yes, and the reason for that is this. The questions are different. Today's question is, and the only thing you're deciding is whether the claimant has established a plausible evidential basis for a good arguable case against the DIFC establishment for breach of contract. So you're not deciding whether that liability for that is established. You're simply looking to see whether there's a good arguable case. That's today's decision. Subsequently, because of course the defendant will file their defence, and they may give rise to other grounds for striking out the claim, but that would not be because there's not a jurisdictional strikeout, as it were, but it would be based on, say, the merits, because it lacks merit. But that's clearly permissible. There's nothing inappropriate about that. One is a jurisdictional challenge, and the other is a challenge based on the merits.
I see, but yeah, please move on. I would.
Can I deal with this? I want to deal with Al-Khurafi, which is.
Yeah, but I just want to. I'm expecting you to finish within 15 minutes. Okay.
I'm grateful.
Please.
I shall be as quickly as I can. Can I just deal with the Al-Khurafi and Bank of Sarasin Alpen case? Now, this is very important still on this point, because if one goes to Al-Khurafi in our bundle of authorities, it's tab 3, and do you have that, Your Excellency?
Yes, I do.
At paragraph 70 to 75 of Al-Khurafi, the DIFC Court of Appeal considered whether a claim had sufficient substance for the court to exercise jurisdiction. Do you see that? And that included whether there was a good arguable case that one defendant could be vicariously liable for the actions of another. So if the claim was brought, so just dealing with that, it is important, Your Excellency, to look at paragraph 70 to 75. Khurafi is a Court of Appeal DIFC authority on jurisdiction, where the court is required to look to see whether there is sufficient substance for the court to exercise jurisdiction, whether there's a good arguable case. That is the test. And certainly the Blue Book, the DIFC rules book, refers to the English Supreme Court 3-stage test in Brownlee and Kafer, which is also in your bundle of authorities, to suggest that that is the appropriate approach for the DIFC courts. Now, if the claim was brought under only B, for example, of the gateway, and the defendant disputed that a contract existed, then the court would look at whether there was a good arguable case there as well that the contract existed. And there is nothing, Your Excellency, in the wording of the JAL to suggest that Gateway A should be treated differently from any other gateway. In other words, on jurisdiction hearings, you do look to see whether there is sufficient substance in the claim. That is absolutely what you have to do. You're not determining questions of disputed fact, but you are looking to see whether there is sufficient substance and a good arguable case. The third point of my 3 points that I wanted to make, if I may, of the four points. Thirdly, it's clear from authorities that on a jurisdiction application, the court will consider both matters that go solely to jurisdiction and matters that will also impact upon matters later, such as merits. And the authority for that is Canada Trust and Stolzenberg. That is an authority that was handed up this morning and inserted in the defendant's bundle of authorities at the back. Canada Trust and Stolzenberg. Do you have that? This is not referred to in our skeleton. It deals with my learned friend's note.
I'm trying to find it.
It's in the respondent's authorities bundle towards the back. It is, sorry, the applicant's authorities bundle, and it's the penultimate authority.
Yes, I got it. Yes.
If I could direct your attention to 553B.
Yes.
Where the court held at
paragraph.
The court considered the issue of the standard of proof for a jurisdiction application from paragraph 553B onwards. And at 553C, it held as follows. Do you see this passage which says, what the court is endeavouring to do is to find a concept not capable of very precise definition, which reflects that the plaintiff must properly satisfy the court that it is right for the court to take jurisdiction. That may involve, in some cases, considering matters which go both to jurisdiction and to the very matter to be argued about at the trial. For example, the existence of a contract. But in other cases, a matter which goes purely to jurisdiction, e.g. the domicile of a defendant, of course, that doesn't involve much inquiry as de facto. Do you see that, Your Excellency?
Yes, yes.
So the point is, there's established authority at the highest levels, which says that on jurisdiction applications, if the existence of a contract is in dispute, then it's exactly the kind of thing that the court needs to be looking into. The fourth point, if I may take you now to that,
Yes.
and that is to refer you to the DIFC authority of Hart and Damak DIFC Company Limited. That is also a new authority added this morning in response very quickly to my learned friend's note, which I received only this morning. And that's the last authority in the
The industrial group.
Sorry, Your Excellency.
Industrial group versus Abdulazim.
It's Dr. Lothar Ludwig Hart and Hart Trading FZE versus Damak DIFC Company Limited et al. Do you see that? It is the 11th. It's tab 11 in my bundle of authorities. Page 356 of case lines.
Yes, I got it.
The point here is that although the first defendant in that case was a DIFC company and the court refused jurisdiction against it, paragraph 60, it was held as follows. If I could take you to paragraph 60.
Yes, Amen. Yes.
Justice Anthony Coleman. If a claimant fails to make any coherent allegation against a centre establishment, although the party may be joined as a defendant, he is not a party against whom the claimant raises a case which can found a dispute. All he has done is put a name on a DIFC court's claim form and nothing else. In those circumstances, no dispute involving that defendant has been properly identified, and the DIFC courts do not have jurisdiction under Article 5A1 to do more than strike out the claim against that party. Where there is no formulated claim, there is nothing which engages the court's jurisdiction. So that is why I say it is very important. It is critical, fundamental that on this jurisdiction application, the court engages with the claimant's evidence as to whether there is a plausible or basis for a good arguable case of a contract between the claimant and the licensed DIFC establishment, which is the only defendant. Now, the only claim, as I say, is for breach of contract between the claimant and the defendant. And if the claimant can't establish a good arguable case that a contract existed with the defendant, there is no dispute remaining that involves this defendant. The court would only have jurisdiction, therefore, in that case, to strike out the claim against the defendant. And you mentioned a moment ago, Your Excellency, as to, well, would you not later apply to strike out? Well, effectively, you're applying to strike out on the jurisdiction application, as these authorities make clear. And this is the DIFC leading authority on this very point that my learned friend seeks to raise today.
Good.
So there is authority. Those are my four submissions in relation to why under Gateway A, it's not just the case of putting a name on a claim form of a DIFC establishment, and that gets you in your foot in the door of the tribunal of the DIFC court. That's not how it works in jurisdiction. We say, respectfully to my learned friend, we say that there is established high authority that you are to look for whether there is sufficient substance, a good arguable case, and whether there is something the claimant raised a case which can found a dispute. And if we, as the defendant, having received this, say, this is ridiculous, we had, the contract was all entirely with another entity, it's a misconceived claim against this particular DIFC establishment, This is the basis for our application to challenge jurisdiction. That's a perfectly proper, perfectly responsible and reasonable way to proceed, and in accordance with the interests of justice that the court would look to uphold. It's perfectly a reasonable and proportionate manner and way of dealing with such a misconceived claim. And so you have to grapple with, we say, whether there is this contract and all of the evidence, apart from suggestion in the claimant's evidence of an oral contract on the 7th of July, points to the DMCC as being the employer throughout the material time. And can I just say this also? One has to look to the pleaded case, and you've seen my having taken you to the pleaded case. There is insufficient particulars of the alleged oral agreement with Mr. Gupta between the claimant and the defendant. And a very basic premise, Your Excellency, of course, is that when one is pleading a breach of an oral contract, it is of the essence that what you have to do is plead the contractual words uttered. You have to plead the words used in an oral contract. And if you look at the particulars of claim, it is wholly lacking. Where are the oral words uttered, the contractual oral words founding this cause of action for an oral contract having been formed and breached? It isn't made out. There is no plausible evidential or pleaded basis for a good arguable case for breach of contract against a licensed DIFC establishment.
Yeah, Mr. Seti, I think unfortunately I have to stop you here, and well, the court would take a 5 minutes break and we'll resume with Ms. Ahmed. And we'll see if there is any time left, then we might refer to you. Yeah, see you in 5 minutes.
Thank you, Your Excellency.
Hello, Ms. Ahmed. I thank you for your patience and calmly sit back.
Good afternoon or good morning, Your Excellency.
Yeah. Is it very difficult if I ask you to start from where Mr. Seti has ended with the late Justice Coleman finding in Dr. Lothar case?
Yes. Your Excellency, it's not difficult at all, but what I was intending to do was take you through the authority which is relevant at this point and then end up with Hart, but I can do that.
I'm sure, whatever. Okay, and you in your order, please.
I'm grateful, but I will deal with the Hart Authority.
No,
what's interesting about the Hart Authority is it is pre-Corinth, it is pre-Tavira, it is pre your judgment, Gavin and Gaynor, and you touched on a very important point that the only fact to be established is whether or not the defendant is a DIFC establishment. And so it's before all of those line of authorities. However, I will deal with it and I will say why Your Excellency can distinguish the Hart Authority with a matter that you're dealing with today. But I do have one eye on the clock, Your Excellency. I appreciate that prayer time will be around 1 o'clock, so I'll try and sort of speed up my submissions. Of course, Your Excellency is completely familiar with the issue of jurisdiction in the DIFC. And therefore, Your Excellency, I may just brush over some of the judgments that I was going to take you to, but let's see how we get on. Your Excellency, my learned friend's submission, quite frankly, is astonishing because it's focused on whether or not there is a claim. That is not the question for determination before you. It is not an issue for you to consider whether or not there is an arguable case. That's in a different common law jurisdiction. It's in a jurisdiction where my learned friend practices in the UK.
I'm afraid I can't hear.
I'm afraid, yes, I have lost her for.
My apologies. For some reason, my mic was switched off. I don't know at which point I lost you.
Yeah, about 30 seconds. Yeah. The last things I've heard, you refer to Mississippi practice in England. That's it.
Yes, that's a different jurisdiction. And whilst those authorities are helpful, but that jurisdiction in respect of determining the issue of jurisdiction is dramatically different from the jurisdiction in the DIFC. And Your Excellency, you will have seen my note, and I don't intend to repeat my note as to why it's so fundamentally different here in the DIFC. And so the simple question we say before you is whether or not the DIFC court has jurisdiction to try the claim. The defendant cannot shoehorn into this jurisdiction application an application for a strikeout. So he can't make a strikeout application in lieu of jurisdiction. It's simply not permissible. It's not a case that where my learned friend says that I am ambitious. It's more so that my learned friend is valiantly trying to ignore the JAM, the gateways, the express language of JAM, the ordinary meaning of JAM, and the line of authority that Your Excellency has been fundamental in developing on jurisdiction. And so my agenda points for today are, and I'm hoping to set out the agenda because, of course, again, I have one eye on the clock and the prayers. So first, Your Excellency, I intend to go through the application and the issue which Your Excellency has to determine by reference to the rules of the DIFC court, and in particular part 12. That ought not to take me any length of time. Second, I intend to take Your Excellency through JAM and the authorities setting out the principles, and that is important. Ordinarily, I would not have done that, but I think in the context of my learners' friends' submissions, it's important to quickly touch upon those authorities, and even if it is for your record or for your reference, point out the paragraphs of those authorities that I rely on. And what those authorities do not say is that the court ought to import into the determination of jurisdiction an arguable test case, a merits test case. It's simply not there. It's not found on any authorities. And my learned friend, while saying he was going to point you to authorities, wasn't able to point to one authority which sets out that there is a merits test. The only authority he pointed to was Karafi, paragraph 74, where he says that there ought to be sufficient substance. However, that's nothing to do with Gateway A. That's B and C. And so we say even that falls short of what, or the proposition that my learned friend is trying to impress upon this court. We say the propositions formulated by my learned friend fall profoundly foul of the law in the DIFC. And then my third agenda point is, Your Excellency, and this rather depends on you, to the extent that it might be necessary to show the relevance or the status of the claim, so to speak, and we say it's not. And we say there is a cause of action, there is a claim, it has been properly pleaded, and at no point in time has my learned friend or those instructing me set out that this is insufficiently pleaded, apart from in the witness evidence. If there is to any extent any residual matter that you want me to deal with in relation to the DMCC contract, I'm happy to do so, but obviously I will leave that in your hands, Your Excellency, because it's my submission and my position that there is no relevance of any of those issues that my learned friend has raised at the outset. So let me very quickly, and without further ado, deal with the first agenda point that I've highlighted, and that is the application. And Your Excellency, the application is at section 1, page 1. And my learned friend at the start of his submissions made some reference to the fact that we were bringing a claim, or rather I clarified in my skeleton argument that I was bringing a claim against Liberty, not bringing a claim against Liberty DMCC. I'm not sure why that wasn't clear to the defendants, because the claim form is against Liberty Steel Group Limited, the DIFC entity, not Liberty DMCC. And therefore the application notice is clear that the application is made by the defendant, Liberty Steel Group Limited, against the claimant. It has always been clear that Liberty DMCC is not a defendant to these proceedings, and there is no claim being brought against Liberty DMCC. Part A sets out what the applicant intends to apply for, and that is that the court has no jurisdiction to try the claim. It's as simple as that. There is nothing there in terms of why that the arguable case test hasn't been met. And the reason being is this arguable case test, the merits test, does not feature in the DIFC law, nor does it feature in the rules. And very quickly, Your Excellency, it may be that I'm preaching to the converted, but if I may just very quickly turn up the RDC, it's at section 745. Part 12.1, a defendant who wishes to dispute the court's jurisdiction to try the claim or argue that the court should not exercise its jurisdiction must apply to the court for an order declaring that it has no such jurisdiction or should not exercise any jurisdiction which it may have. I've brought Your Excellency to this because it's very clear the basis upon which a defendant can contest jurisdiction. Dramatically different from that situation in the UK, because in the UK it is the claimant, when seeking permission to serve outside of the jurisdiction, has to convince the court that the provisions of the CPR 6.2 or 6.3 have been satisfied. That's not the case here in the DIFC. In the DIFC, you effect service, and then it's the defendant that mounts a jurisdiction challenge pursuant to 12.1. The other point that arises out of 12.1 is that the defendant doesn't dispute or doesn't argue point 12.1.2. For instance, the defendant isn't saying as an alternative, if DIFC court you have jurisdiction, don't exercise it. So it's not bringing an FNC argument, it's not bringing a necessary proper party argument, it's not bringing an argument that the DIFC court is not a proper forum, an appropriate forum, and it can't. It cannot, because squarely and fairly the defendant is a DIFC establishment, and therefore the claim does satisfy Gateway 1A or 5A 1A. I beg your pardon. Now, pausing there a second, I've referred to the contrasting regimes in the DIFC and in the UK courts, and that's really kind of the focus, or one of the focuses of my note file this morning. But just putting aside sort of what the DIFC courts can do in terms of English law, I've also this morning sent the case of the Industrial Group Limited. It's a Court of Appeal authority, and Your Excellency will be familiar with it, having sat on the bench. It's a very recent authority issued on the 20th of September 2020. And the point is this, and I'm not going to run through the judgment itself, apart from to flag up the relevant paragraphs, and those are paragraphs 103, 104, 105, 107, 111. And Your Excellency, again, for the reasons of time, I'm not going to run through them. Your Excellency is familiar with it. Your Excellency sat on the bench when the Court of Appeal was dealing with this. But the point is this, that it is impermissible, we say, for the DIFC court to apply UK principles. And the merits test is profoundly a UK principle. In that case, Mr. Hamid was trying to bring a case for malicious prosecution and abuse of process, and was trying to shoehorn it into the the DIFC law of obligations. And it was found at first instance that the law of obligations does not allow for a cause of action in malicious prosecution or for an abusive process, and therefore it was impermissible for Mr. Hamid to rely on common law principles from the UK to try and bring a cause of action which simply didn't exist under the law of obligations in the DIFC. And so in the context of this case, referring to the dicta of the Court of Appeal bench in the case of the Industrial Group, the Court of Appeal has clarified the source of DIFC law and has corrected the widely held misconception that somehow the DIFC courts can apply UK law or it incorporates UK law. That's not correct, and that's what my learned friend, astonishingly, valiantly, ambitiously, to use my learned friend's terminology, is trying to do exactly that this morning. And we say that that sort of approach ought to be completely disregarded. DIFC law is statutory. JAL is statutory. JAL does not come from the UK, and therefore JAL, on the face of it, ought to be construed in its ordinary and plain language. There is no insurmountable hurdle when you come to consider 5A, for instance, that the claimant has to satisfy a merits test. It's simply not there. It cannot be found, and therefore we say the only factual or the only merit that the court has to decide is there a DIFC establishment pursuant to which a case is being brought? Yes, there is. Statement of fact. End of the argument. And Your Excellency, just sort of kind of as a side point, the DIFC court has now been operating for nearly 16 years, and it's been required to explore all nuances of jurisdictional arguments arising out of the statutory regime, a codified statutory regime. So in the context of what my learned friend is trying to argue today, there's simply no room for it, no room at all. So then turning to my second agenda point, and that is dealing with JAR, dealing with the authorities on the point of jurisdiction. Very quickly, I just want to bring up JAR because, again, in the context of my learned friend's submissions, I consider in my submission, it's important to have a look at the express language of JAR. And Your Excellency, that's at section 7, page number 1. And if we turn to Article 2, which sets out the definitions, and we can see the state is defined: emirate, ruler, DIFC, president, DIFC bodies, and the relevant part is at 7.2, where we see Dubai courts and DIFC establishments. Now, this is important in the context of what my learned friend was saying by reference to Corinth. If we look at DIFC establishments, any entity or enterprise established, licensed, registered or authorised to carry on business or conduct any activity within the DIFC pursuant to DIFC laws, including licensed DIFC establishments. So in the first line, DIFC establishment, the definition talks about licensed establishment, and then licensed DIFC establishment is in turn defined as an entity or enterprise registered or authorised by the Dubai Financial Services Authority to provide financial services or conduct any activities in accordance with the DIFC laws. So the licensed DIFC establishment is defined as an overarching DIFC establishment. And then we move forward to Article 5 itself, jurisdiction. A, the Court of First Instance. The Court of First Instance shall have exclusive jurisdiction. So it provides for exclusive jurisdiction to hear and determine A, civil or commercial claims and actions to which the DIFC or any DIFC body, DIFC establishment or licensed DIFC establishment is a party. So let's pause there. That stands separate from B and C, as well as E, and we say E is also relevant to this issued jurisdiction. 5A1A are actions to which the DIFC or any DIFC body, DIFC establishment or licensed DIFC establishment is a party. So we say that in the context of what my learned friend was saying about Corinth, yes, it did deal with whether or not you can pursue a claim against a branch of a parent company. It did, but there is no distinction in 5A1A of a licensed DIFC establishment or a DIFC establishment. The two sit in the same position. They're synonymous with each other. And therefore we say Corinth is good authority, and it's a Court of Appeal authority and supersedes anything that Hart may say. But we can now turn to Corinth.
Yeah, but if you understand Mrs. Setti's argument, said Corinth did not say, it said what it said, but it did not said you cannot discuss the merit of the case. What Mrs. Setti said, but I'm letting you aware what he said.
Of course, and I disagree. That comes as no surprise. If we can turn at Corinth, please, and look at what Corinth in fact said. The provenance of the authorities at 784, so it starts at 784. And I'll take you to Justice Sir John Chadwick's dicta in Corinth, and that's at 790. And Sir John Chadwick added his own dicta, his own judgment to this, because Sir John Chadwick was dealing with the Karafi case when there was an amendment to the old jurisdiction law. And so, right. and the amendment was pursuant to law number 16 of 2011. And he wanted to deal with Corinth in that context because the Corinth case had been brought, or the application had been brought by reference to the first jurisdiction law before the amendment. And so if we move to 792, and that is paragraph 83. So adopting the approach in the present case, the determinative question becomes whether access to the jurisdiction of the court of first instance through the gateway provided by paragraph A, and we're simply dealing with paragraph A, of Article 5A1 of the original law is restricted, where reliance is placed on the fact that a party to the proceedings is a licensed DIFC establishment to cases where the civil or commercial claim is connected with or perhaps arose out of. The provision of the conduct by the entity or enterprise identified as the relevant licensed DIFC establishment of financial services or other activities in accordance with the DIFC laws, which the entity or enterprise was licensed, registered or authorised by the Dubai Financial Services Authority to provide or conduct. And that's the question he's posing. And just pausing there, I say licensed DIFC establishment is the same as a DIFC establishment by virtue of JAL. Paragraph 84. In my view, the answer to that question is no. Access to the jurisdiction of the court of first instance through the gateway provided by paragraph A, Article 5A1 of the original law, as amended by law number 16 of 2011, is not so restricted. Whatever may have been the position before the issue of Law 16, and I should not be taken as indicating any disagreement with the view expressed by the Chief Justice in his judgment on this appeal, the case of civil or commercial claims and actions to which a licensed DIFC establishment is a party, once it is shown that the party by or against whom other activities in accordance with the DIFC laws, the requirement under paragraph A is met, the jurisdiction exists ad hominem, there is no further transaction-based requirement comparable to those imposed under paragraphs B and C of Article 5A1. So there's 2 points that arise from Corinth. We say that yes, in Corinth they were dealing with a branch and with a DIFC licensed establishment, but there is no difference between a DIFC licensed establishment and a DIFC establishment when you consider the definitions in JAL and when you consider 5A1A, they are synonymous with each other, number one. Number two, when you consider Gateway 5A, there is no transaction-based requirement. And in any event, I say transaction-based requirement isn't the same as an arguable case test. It simply isn't. So that's what we say arises out of Corinth. Then the next case, if I may take you to the second judgment, and again, this is sort of establishing the general principles of the DIFC court, is the IGPL case, and that's at 70101. Again, this is a Court of Appeal judgment, November 19th, 2015, and it's the next judgment that deals with Gateway A in the line of authorities. And if I can take you to paragraph 100, and that's at 7115. And just pausing there, the second principle to be ascertained from the IGPL case is that it affirms Corinth that there is no transaction-based requirement and moreover, no merits test when considering Gateway A. It's simply not relevant. And this case was again a case about whether or not you can bring a case against a branch, and the branch in question was Standard Chartered Bank, because the actual conduct was with a branch outside of the DIFC. And IGPL confirms Corinth. And if I can, I've taken you to paragraph 100, and this is just for your reference. So 102 it refers to Corinth at 83 and 84, that beyond the criterion set out above, and that is whether or not there is a DIFC establishment, there is no further transaction-based requirement, such requirement that the dispute must concern the activities or conduct of a disputant's DIFC branch. So therefore, you don't need to go any further other than, is it a statement of fact that there is a DIFC establishment against whom a claim is made or brought?
Sorry, again, where are you reading, Ms. Ahmed? What is that?
Paragraph 102, it's at
102.
7-115.
Yes, yes. I got it. Yes.
Yeah, and in that case, I mean, we were representing at the Court of First Instance the applicant, but it went to the Court of Appeal, and it was Mr. Michael Joyce Pratchett that was arguing that Corinth was wrongly decided. And if we can just very quickly, for your reference, turn to paragraph 122, and it's 7-118. Prior to that paragraph, the Court of Appeal is considering Mr. Joyce's arguments as to whether or not Corinth has been or was wrongly decided. And they found that accordingly, we are not persuaded by any of IGPL's arguments that Corinth was wrongly decided. And so it applies and it affirms Corinth in that, and that's a Court of Appeal judgment, in that there is no transaction-based requirement. What you don't see in any of these authorities is any reference to any sort of merits test. Transaction-based requirement is not a merits test. It simply isn't. And even if it was, what the Court of Appeal is saying, it's not relevant for Gateway A. It's just simply not relevant. And this neatly takes me on to Your Excellency's decision in Gavin and Gaynor. And the principle to be derived from Gaynor is that the only fact that needs to be satisfied is whether the defendant is a DIFC establishment. And Your Excellency, the decision is at 7-128. It's a decision that you issued on the 3rd of April 2016, so some 5 years after the Hart case, if my maths is correct.
Oh, yeah.
After the earlier Court of Appeal judgments. And if I can quickly take you through paragraph 45, 7-132, and this is where you discuss the case. And in that case, the defendant raised 3 arguments as to the validity of the arbitration agreement, the availability of jurisdiction in the IFC courts, and an issue in relation to abuse of process. And at paragraph 45, Your Excellency sets out the critical question for jurisdiction when it comes to a party, trying to establish that the Gateway 5A has been met, is that the defendant contends that the substantive contract is not subject to the jurisdiction of the IFC courts because none of the gateways provided by Article 5 of the Judicial Authority law apply in these circumstances. In 46, you go on to look at the jurisdictional gateways, and at 47, I beg your pardon, at 58, no, sorry, I've got the wrong reference. Oh, here we go, 47, I was correct. In 47 of your decision, Your Excellency provides that, in my view, the only way for the claimant to properly use the gateways of the Judicial Authority law to compel this court to accept their application to appoint the arbitral panel is for the claimant to establish one of the following facts with reference to the Article 5 gateway cited above. And one of those facts is whether or not A is satisfied, B is satisfied, C is satisfied, or D is satisfied. So, Your Excellency, the only fact that needs to be satisfied is whether or not one of the parties is a DIFC establishment or licensed DIFC establishment. We have satisfied the fact of the defendant being, or who is a party to this claim, is a DIFC establishment. Given that fact has been satisfied in accordance with your judgment at Gaynor, Article 5, 1A, 5A, 1A has been met. We then turn to Tavira, Your Excellency. And if I could invite you to turn up 7-154. This is again a court of first instance judgment on 17th of December, presided over by Justice Sir Richard Field. And it was Mr. Tom Montague Smith, KC, QC at the time, who was arguing for the claimant that the jurisdictional gateway has been met. And very quickly, the principle to be derived, we say, from Tavira is that it concerns whether, and as my learned friend quite rightly articulated, it concerned whether or not jurisdiction had been established given the cause of action arose after the DIFC establishment had been incorporated. And so Justice Richard Field said that wasn't, that was irrelevant. The only relevance or the only fact to be established is whether or not there is a party in the DIFC that is a DIFC establishment against whom a claim is made. That's the end of the matter. And if I can turn you to the discussion that's at 7-160, and it starts at paragraph 28. And I'm not going to read through this, but very quickly, paragraph 28 talks about how to construe Gateway 8, and it must have regard to the interpretation placed on that provision in cases decided by the DIFC courts, in particular the DIFC Courts of Appeal. Paragraph 29 then deals with Corinth and recites Corinth paragraphs 66, 67, 68, 69, 70. It then goes on to, and 71. We're moving over to 7-161. It recites Justice Chadwick's decision at paragraph 83 and 84, which I've already taken you to. Paragraph 31 expresses that Justice Ali Al-Madhani agreed with both judgments, and of course Your Excellency was on that bench. Paragraph 32 deals with the Karafi judgment, and that simply deals with how to interpret JAL, because obviously the Dubai law, JAL, has been issued and promulgated in Arabic, and that's been interpreted over or translated over to English, and that simply, paragraph 32 simply deals with that point. 33 deals with investment group and Standard Chartered Bank. 34 then goes on to refer to the Afras case, which was the Barclays Bank. Afras was brought in as an additional defendant to the Corinth case. So Corinth, Barclays Bank then brought Afras in. Afras then filed a jurisdiction argument. So John Chadwick dismissed that application. Then we go to paragraph 35, the case of Lutfi, which we say isn't relevant, and it's in any event an SCT case. Paragraph 36, again, the distinguishing factors of Corinth. And then moving down, if I can perhaps take you to paragraph 38, which talks about how to give JAL its legal meaning and considers the case of Pinner and Everett. And then paragraph 39 is the relevant part, which says, no reliance was placed by either side on any difference between the Arabic version of Gateway and its English translation. And that was the point that was being dealt with in his paragraph 32 of this judgment. In my judgment, given the interpretation that the Court of Appeal has accorded to the definition of licensed establishment in Corinth, the plain meaning of the words of Gateway A, sorry, my authority is cut off. Regardless of whether the events giving rise to the claim occurred before or after that status was acquired, each of the jurisdiction gateways provided for in Article 5A1 of the Judicial Authority Law is freestanding with its own jurisdiction criterion. The sole criterion for jurisdiction in Gateway A is the starting point. Either the defendant or the claimant as a licensed establishment at the time the test for jurisdiction under Gateway A is being applied. And that's where my sole criterion test comes from, that you may have seen in my skeleton arguments, both in the first skeleton argument and in my note. The sole criterion test for Gateway A is whether or not a party to the claim is a DIFC establishment. If I can then quickly turn to 41. Further, I do not accept that the consequences of construing Gateway A so as to give its natural and ordinary meaning are so capricious or absurd. And to be fair to my learned friend, he doesn't say anything about being capricious or absurd, or that not to have a merits test would be capricious or absurd. It is to be inferred that the intended meaning of Gateway A is something different from that which is to be derived from its natural and ordinary meaning. Chief Justice Wong at the time observed in Corinth, there is nothing unusual about the DIFC courts having jurisdiction over a foreign company with a branch office in the DIFC in respect of a claim that has no immediate connection with the DIFC other than the presence of the branch office. True, it is that there may be circumstances in which Gateway A gives rise to an exorbitant jurisdiction where some other forum is clearly more appropriate. But in such a situation, the FNC doctrine will be available when the competing forum is outside the UAE and where the competing forum is located in another emirate within the UAE. Pausing there a second, there is no FNC argument before you today. The Union Supreme Court is empowered to decide any conflict of jurisdiction thereby arising. As for jurisdictional contests between the DIFC courts and the Dubai onshore courts, where the defendant is based in an onshore Dubai contest, based onshore and Dubai contest jurisdiction asserted by a claimant under Gateway A, if there is a true jurisdictional conflict, that conflict can be resolved under Article 2 of the Dubai Decree number 19 of 2015. There is no such application before you as well. Where there is no such conflict, and we say there is no such conflict, and that's why there is no such JJC application or an Article 2 application before you, or a stay application, the DIFC courts will have exclusive jurisdiction if the claimant satisfies the definition of DIFC establishment or licensed DIFC establishment. This being the will of the ruler as expressed in the clear wording of Gateway A. And therefore, we say it is the will of the ruler that if there is a party that is a DIFC establishment, the DIFC court, pursuant to JAL 5A1A, shall have exclusive jurisdiction to hear and determine the claim. That's the end of the matter. It's the will of the ruler not to import into this 5A1A any merits test at all whatsoever. So, tying all of this together, and then I will deal with the Hart case. Under Corinth, for the 5A1A gateway to be met, there is no further transaction-based requirement that the dispute must concern itself with the activities or conduct of a DIFC establishment. Under Gaynor, the claimant only need to establish that one of the parties is a DIFC establishment, which it is. And under Tavira, the sole criterion for jurisdiction is that either the claimant or the defendant is a DIFC establishment or a licensed DIFC establishment. This being the will of the ruler, the defendant is a DIFC establishment. We say that's the end of the matter. Coming back to now your first question that you posed for me, Your Excellency, and my apologies that it's taken me sort of a while to get there, but it was important to go through these authorities to make sense of the Hart case as well. My learned friend valiantly, ambitiously, is trying to save the day for his client by relying on this case. But in my submission, this case doesn't actually help my learned friend, because firstly, it's a court of first instance judgment. It was issued on the 4th of April 2010. Matters have far superseded what was going on in the DIFC in 2010. Third, this authority, in fact, deals with the principle that the court can retrospectively extend time to file a jurisdiction application. That's the principle to be derived from this case, nothing more, and that's from paragraph 7 of this judgment, which deals with that principle. Paragraph 7 is also important, and if I can turn you to paragraph 7, and Your Excellency, I can't refer to a page number because I don't have the references to the bundle, but I'm assuming
it's 357. 357.
Grateful.
I got it open, yeah.
I'm grateful, thank you. So in this case, the first defendant was Damac Company Limited, and obviously we know Damac Park Towers is in the DIFC, the only Damac entity in the DIFC, I have to say. And the claim was brought against Damac DIFC, and it was Damac DIFC that applied to strike out the claim because clearly it was saying that there was no cause of action and no reasonable prospects of success. And it was only after the strikeout application that had been made that the claimant sought an order that the court had jurisdiction to deal with this matter. So just pausing there a second, the claim's been served. The defendant isn't contesting jurisdiction because clearly it's a DIFC establishment. It's bringing a claim for strikeout. And in the counter application, it's the claimant who wants an order, a declaration that the DIFC does have jurisdiction. And that's, we say, procedurally quite distinct from our case. There is no application before you for a strikeout application or a strikeout of the claim, and nor can there be, as Your Excellency pointed out. Any strikeout application can only be made once the court has seized jurisdiction in any event. And so this isn't a proper forum or a proper hearing for any sort of merits analysis to take place. Then if I can perhaps turn to paragraphs 9 of Hart, in which Justice Sir Anthony Coleman dealt with the jurisdiction application first.
But if you see paragraph 11, it says the essence of this case is that the advance on behalf of the first defendant can be shortly stated. The defendant was not a contracting party.
Yes. Yes.
Yep.
So if you look at paragraph 10, the essence of the case advanced on behalf of the first defendant can be shortly stated. You're right. The first defendant was not a contracting party. Each contract contained a governing law and jurisdiction clause, as distinct from the DIFC courts. There was in any event no jurisdiction, and if there was jurisdiction, the parties had contracted out. Let me deal with all of those positions first. In this case, the Hart case, there was in fact a contract with a different entity. We say that the claimant has a contract, albeit an oral contract or an implied contract, but we have pleaded a contract against a DIFC entity. In this case, there was no pleaded contract, or there was no contract pleaded against the DIFC entity. That's the first point. And in terms of the pleaded contract, very quickly for your reference, if we turn to section 1(9), we plead that there is a contract against the defendant. We say it's an oral contract. We say there was a novation. Alternatively, there was a novation of the DMCC contract. We also say that you can construe a contract, or the court can construe a contract, by looking at the conduct of the parties. And all of that's been pleaded at 9, 10, 11. And whatever criticisms my learned friend has of the pleading, he cannot say that we haven't pleaded there is a contract against the defendant, because we have. In the Hart case, there was no pleaded claim against the DIFC entity. There simply was no contract. And that's why, in that case, it was struck out, or rather the court said that there was no jurisdiction because there was no contract pleaded against the DIFC. Here, there is a pleaded contract. I'm just reviewing this to see whether or not there is any other relevant paragraph. And why do I say that about Hart? We turn to 48, paragraph 48, which says, in these circumstances, it is my judgment inconceivable as a matter of inference that the parties would enter into a contract for sale of realty in either DIFC or non-DIFC Dubai, in which they agree that the contract should be governed by the laws of the DIFC and that any legal action or proceeding with respect to this agreement should be subject to the exclusive jurisdiction of the courts of the DIFC. Again, distinguished from our case. This isn't a real estate contract, it's an employment contract. We have pleaded that there is an oral agreement. We have pleaded that there is an inference, and we say that there is a very high inference that one can draw from the primary facts that there was a contract between the defendant and claimant. And Your Excellency, I don't want to stray into the facts of the case because I don't consider it necessary. But in terms of my learned friend's argument that the DMCC contract was the relevant contract, we say it was not, number one. That's our first submission, because that contract was a sham in the employment context sense, not in the commercial sense, not in the snook sense. It was a sham because it did not reflect the reality of the relationship. And I can take you very quickly, I mean, let me just very quickly deal with this point, because I do think it's important in the context of the DMCC contract and in the context of what my learned friend has said about the DMCC contract, and I can deal with it very quickly. If we turn to the DMCC contract, and actually the DMCC documentation, 330, this is the employment contract cover sheet, just very quickly ticking off why it doesn't reflect reality. The date of the contract, 1st of August 2020. That's not correct, because the claimant was offering his services from the 1st of January of that year. His job title, it says sales. He was clearly not a salesperson. He was a CEO. Probation period, there was no probation period. His basic monthly salary of 70,000 plus other monthly allowances of 30,000. Your Excellency, there is no dispute amongst any of the parties or the evidence that you have.
That is signed contract. That contract is signed, isn't it?
I beg your pardon?
Yeah. That is a signed contract between
parties. It is a signed contract, but it does not reflect the reality. And I'm going to go through the clauses of the contract very quickly, because that remuneration was not what the claimant was paid. The claimant was in fact
the written document reflecting reality, unless it's stated otherwise.
I beg your pardon?
I said usually the document reflects realities.
Well,
a signed document reflects realities.
Well, this contract does not, because the
That's
parties were
performing. That's the form of the agreement usually. I mean.
Well, the parties weren't performing in accordance with this contract. He was getting paid $144,000, which is significantly different after this contract was entered into. And in fact, 331, if I can just go over the page, this is quite an important point, because what it says is, please note that DMCC requires the company to notify DMCC of any changes to the information set out in this employment contract. This is an undertaking given by the DMCC entity, by the company, to notify DMCC of any changes, and it's signed on behalf of the company. They did not do that. In fact, the inception of this contract is all wrong. He's not a salesperson. He wasn't drawing 100,000.
What happened if the DMCC are not notified? What happened to contract? Invalid? Invalid?
Yes, we say yes. The contract is of no consequence because it's been superseded by a different arrangement. And that different arrangement was, you are a CEO. You are going to draw a salary of $144,000. You are going to operate, and this comes back to actually one of the points that my learned friend says. You are going to operate not just in the territory of the DMCC, but you're going to operate in Europe. You're going to operate in London. You're going to operate in Romania. You're going to operate in Australia. So it does.
Mr. Ahmed, are you arguing that that contract has never been enforced, or it's enforced for some time, then novated, and then it's another contract started with this new entity?
I am arguing, number one, yes, the claimant signed it in August 2020, but that contract did not reflect reality because the parties did not adhere to the terms of this contract. They weren't performing to the terms of this contract. And in fact, it was the only purpose for entering into this contract was to get a visa. None of the parties were acting in accordance with this contract. This contract was superseded, therefore, by the DIFC contract. And again, let me make good this argument as to why
you mean superseded from first day? That's one question. Is it from first day? It's never been executed? It's never been enforced,
been
never come to
complied
life.
with, yes.
That's what do you mean?
Yes, it's never been complied with. It has never been complied with. And just in terms of kind of where I get to with this sham contract argument, very quickly, if I can perhaps.
Well, no, believe me. I mean, you didn't have to spend a lot of time. I prefer you save your time for the most important. I mean, you got 12 minutes to go.
Perfect. Your Excellency, for your reference, where I go to the sham contract, it's in my authorities bundle, 7-66. It is, or 7-78, paragraphs 55 and 57. Of course, and 57 very quickly, in a case involving a written contract, the tribunal will ordinarily regard the documents as a starting point, but it may then have to ask whether the parties ever realistically intended or envisaged that its terms, particularly the essential terms, will be carried out as written. No, they did not in this case, and I have given I have set out in my skeleton argument why the document on the face of the documents, this contract did not reflect reality. The claimant in his witness statement has given chapter and verse, and I'll give you the reference, PK1, 2-15 of the bundle, paragraph 32. Why, when my learned friend says, well, look at the contemporaneous documents, we say those contemporaneous documents aren't worth the paper they're written on, because each and every one of them is inconsistent with reality, and it's inconsistent with every other written documentation produced by the defendant. And so we say that the DMCC contract does not reflect reality, and very quickly, again, because my learned friend took you to this, paragraph 1.1, wrong title, he's not a salesperson. Paragraph 1.3, this is quite interesting when my learned friend took you to this, 335. The employee shall not during the period of his or her employment work outside the territory for another person. The claimant was. He was working in Europe, he was working in London, he was working in Romania, he was working in the DIFC. And so this doesn't apply, and it wasn't enforced as well, using Your Excellency's language.
What about the fact the FC comes 1.5 years later after that contract, which you said it never reflects any realities, not even for a single day?
So we say it supersedes. The DIFC contract supersedes the MC contract.
Oh, no, you said from day one, it's never been executed, it's never been relied on. That's what you just said a couple of minutes ago. And
what I said was that, number one, it didn't reflect reality. The only reason why it was entered into was for the purposes of obtaining a visa. These terms.
Yeah, but I said what I find isn't it very difficult to argue? The reality is from day one, from the date of that previous DMCC contract, you claiming the employer was the DIFC company, even before it did exist.
No, I'm not claiming that. I beg your pardon. I'm not claiming that. I am saying, and I'm so sorry if I've suggested something ineloquently. I am saying that the claimant entered into the employment terms, and you've been taken to the employment terms. Those were overarching terms pursuant to which the claimant was providing services to GFG, and you've heard about GFG having these core pillars. And at that time, he was providing his services from the 1st of January. And he was based in the UK, and he was based in Europe. Then he comes to Dubai, and he needs a visa to work in Dubai. The only entity that GFG Alliance has at that time is the DMCC entity. And therefore, whilst the employment terms apply and the parties conduct themselves in accordance to the employment terms, he is invited by DMCC to enter into this DMCC contract for the purposes of obtaining a visa. That's it. That's the only purpose of this DMCC contract. And none of the parties are actually performing this DMCC contract when it comes to his title, when it comes to his remuneration, when it comes to the territories that he is operating in, when it comes to additional benefits, not recorded properly in this DMCC contract. And furthermore, the entire clause agreement isn't even adhered to, because the entire clause agreement, actually is put aside, it's abandoned. When it comes to remuneration, when it comes to accommodation, when it comes to all the other benefits, all of this is put aside. So yes, while on the face of it, one would say the DMCC contract is the one that he entered into, but that was just for the purposes of visa. Then we get to when the defendant is incorporated in the DIFC. He's incorporated into the DIFC, it's incorporated into the DIFC on the 18th of February. After that date, on the 7th of July, there is a conversation between Mr. Gupta and the claimant, and it's Mr. Gupta's decision that the claimant will be working from the DIFC because the DIFC is going to be the headquarters of the GFG Alliance. And that's where we say the oral contract is formed. And curiously, that oral contract was pleaded at paragraph 7, I think it is, of the particulars of claim. It was said that I entered into, or the claimant entered into, an oral contract with Mr. Sanjay, paragraph 9, with Mr. Sanjay Gupta, who agreed to this oral contract on behalf of the defendant. Now, in support of this Part 12 application, we saw no evidence from Mr. Gupta disputing that. The only time Mr. Gupta gave evidence was in reply. Now, of course, these are all facts for a trial. It's all matters and submissions for a trial. But in terms of the case itself, to put it very clearly, we say on or about the 7th of July, pursuant to a conversation with Mr. Gupta, the defendant and the claimant entered into an oral agreement that the claimant would be an employee of the DIFC entity. So that's the case, Your Excellency.
I see the point. I see your point, yes.
I'm grateful for that. Now, again, very quickly, just dealing with sort of, I've dealt with Karafi, so I don't need to go there again. I've dealt with the elements of JAL 5A. And Your Excellency, in terms of the elements of JAL 5A, we say simply that it's been established on the case law, on JAL itself, and there is nothing before you that, or rather my learned friend hasn't pointed you to any authority which says that the JAL 5A test ought to be determined on any sort of merits analysis. It ought not to be, and that's as simple as that. Leaving 5A there, I'm going to very quickly deal with 5B and 5C, because we say, not that we say it's necessary to even consider 5B or 5C, because we've established the Gateway 5A test, but we say we also fall within 5B, 5C. Very quickly, Your Excellency, I'm going to run you through the authorities, but not take you through them. Karafi, paragraph 60, deals with Gateway B, and that's at 5-98 of this of the judgment. Paragraphs 63 to 65 of Karafi deals with Gateway C, that's 5-99. The test for Gateways B and C have also been referred to in Corin, and that's at paragraph 84, and that is where the transaction-based requirement comes in. And we say the transaction-based requirement doesn't equate to a merits test or an arguable case test. It equates to the test that Your Excellency identified in the case of Tutora. And if I can just take you to Tutora very quickly, and that's the only authority I'll be taking you to. It's at 7-154. Sorry, 7-165. Paragraph 29 is where the discussion starts. Paragraph 30 deals with the fourth defendant's jurisdiction application, and that is with respect to 5A1B. And at paragraph 35, your decision is that you find that the guarantee, and very quickly you'll recall that the guarantee was in respect of a loan given to a DIFC restaurant, Tutora the restaurant, and the guarantee had a Dubai court jurisdiction clause. And in fact, Your Excellency determined that the guarantee was part of the claim because it could be closely connected to the DIFC loan agreement, and therefore it falls under the jurisdiction of the DIFC courts pursuant to Article 5A1B of the Judicial Authority Law. And we say that that is where Your Excellency enunciated your close connection test. And we say that close connection test isn't a merits test by any stretch of the imagination. It would be a quantum leap to say that it is. And it's simply whether or not there is a close connection and whether or not a close connection can be satisfied. And going back to the authority of Gaynor, in that authority, Your Excellency concluded, and for your reference and for your note, it's at paragraph 60 to 63, reference of the bundle 7-134. And Your Excellency found that a letter dated the 4th of May 2022 discussing meeting arrangements in the DIFC that were to occur the next day was evidence that the transaction between the parties took place at least in part within the DIFC, which means that the parties transacted business in the geographical territory of the DIFC. And what's clear from that judgment is, and those paragraphs, is what you're not saying, that there needs to be an assessment of the merits. For instance, you don't go on to determine whether or not there was merit in binding jurisdiction because the letter gives rise to a good arguable case or not, or the letter gives rise to a good claim or not, or a cause of action. We say it's not necessary. That's why you didn't do that. And so just dealing with this close connection test, we say that the claimant has satisfied the close connection test because, and if I can perhaps just run you through a couple of documents that satisfy the close connection test. 3-71, or rather 3-69.
69, yeah.
Yes, this is an email from the DIFC entity inviting the claimant to a ceremony for the opening of the DIFC office on the 7th of July, 7:30. And the claimant's evidence is that it's after this ceremony that he then goes to the defence Sanjay Gupta's house, and that is where the oral agreement's formed. Then 3-71, this is an email, 11th of July 2021, subject DIFC office, Wi-Fi, sent to Mr. Kahlon, the claimant. I hope you're all well and enjoyed your weekend. I would like to inform all of you of the Wi-Fi protocols and login information for the new office being the DIFC office. This is sent from GFG Alliance in London, but it's in respect of the DIFC office and the claimant was copied into it. 3-72, this is the gate access card that was given to the claimant to enter the offices of the defendant, and that was the entire 12th floor at Central Park DIFC. That 373 is the first page, 374 is the front end of the card, and 374 shows the back of the card. 3-75. This is an email sent from Ms. Anas Hilali. It says GFG Alliance, but it's actually the signature records the address, DIFC address. And that is in relation to information about the cyclone, but the point is that it's sent from the DIFC address and the claimant received that. 3-76, 3-77. This is again an invitation to another ceremony, another festival, rather, the Diwali festival, from GFG Alliance, 3-77, but it's a DIFC address. And
yeah, Ms. Ahmed, I would like to remind you what Mr. City said about this, most of this document, and he said it's a proof, it's not of a contracting, but it's a proof of this guy come and work from the DFC for some time. Like he can work from anywhere in the world, but it's not a proof of contract. It's nothing to do with having a contract with a new party.
But Your Excellency,
what I'm saying. Yeah, I'm just reminding you what he said.
But this application doesn't have to determine whether or not there's a contract. It doesn't. For Gateway A, we only have to determine. I see my learned friend laughing, but. For Gateway A, we only have to establish that there is a DIFC establishment.
The license enough, that's what you think.
That's enough. Even for B and C, we say we don't have to establish a contract.
And you said
have
there is
to-
already concession in the case.
I beg your pardon?
You said there is a concession that.
Absolutely, my learned friend has made that concession at paragraph 43 of his argument. I mean, I even remember the paragraph because I nearly fell off my chair when I read it.
Yeah, I would understand. He disagree with you because he still have to see to connect the entity with the cause again. I mean,
That's not provided for though.
I
in the
understand.
bill.
Understand.
And
Yeah.
so he makes the concession. Gateway A, there is a DIFC establishment. He makes that concession.
Well,
The
you know what?
only-
I think the only I do really have the full picture of each party's argument for now, Ms. Ahmed.
Your Excellency, I'm only going to take
If you want to
it one-
conclude, yeah.
Yes, one more letter.
Yeah.
It's at 3-80. 10th of November 2021. It's sent by Liberty Steel Group about Mr. Kahlon, the claimant's bonus. This is a letter sent from the DIFC entity saying to the claimant, in line with the company's discretionary bonus approach and reflecting upon your performance to date, you have been awarded the below. And so coming back to this close connection test, B and C, gateways B and C are also established, we say.
This is DFC letterhead, isn't it?
It is, yes.
Yes.
Furthermore, when we talk about contemporaneous documents, there is the claimant writes to the defendant, and very quickly, 3-98 on the 16th of February, he says in terms, 3-99.3, the email starts at 3-98, it goes over at 3-99. Paragraph 3 says in terms, all of us are operating from the DIFC for the last 8 months and the office is going to be there now. Hence, contract should be as per DIFC guidelines. At no point do you say in any of this contemporaneous evidence emails, the defendant say, oh no, you've got a DMCC contract. You don't have a DIFC contract. You will find no evidence of that at any point. The only time the DMCC contract was raised in the context of this jurisdiction application. And so,
but does that mean there is another place of work, Ms. Ahmed? Does that mean there is, it's not just DFC, otherwise the language might be something else completely. This is the only place where you can work from, maybe?
within, well, the law is based ordinarily or within the DIFC, Your Excellency. But again, Your Excellency, well, let's not get drawn into these arguments. The only reason why I'm taking you to these...
You brought these arguments, not me,
Yes.
Ms. Ahmed.
Yes, but the reason why I'm taking you to this is for the close connection test, Your Excellency, that you have elucidated in your tutorial, in the decision in Tutora. I'm simply taking you to these documents to show you that there is a close connection with the DIFC. So tying all of these threads together, my learned friend has ambitiously attempted to import into his arguments a merits test. There is no room for a merits test. My learned friend has failed to, despite saying there is authority, has fundamentally failed to point you to any authority whatsoever in the DIFC that would give rise to any sorts of merits test. In contrast, in my submission, I have taken Your Excellency to Corinth, which talks about transaction-based test requirement, not where you consider, where Your Excellency has to consider 5A. There is no transaction-based requirement. I've taken Your Excellency to Gaynor, where Your Excellency's decision is the only statement of fact to be established is whether or not the DIFC entity, or whether a party is a DIFC establishment, the defendant is. I've pointed Your Excellency to the sole criterion test identified in Tavira. The claimant meets that sole criterion test, and therefore Gateway 5A has been established. That could be the end of the matter, but we say even Gateway 5B and 5C has also been established, given the close connecting test elaborated by Your Excellency in Tutora. There is close connection, and therefore the DIFC court has jurisdiction. The DIFC court cannot be and ought not to be persuaded by any UK authority. It is impermissible in light of the Court of Appeal authority that I took you to in the industrial group case. And in those circumstances, Your Excellency, unless there is any other issue arising out of my learned friend submissions or my learned friend skeleton argument, or unless there is any other issue that Your Excellency would like for me to address you on, I'm going to leave my submissions there. Your Excellency, before I do, let me just actually go to one final point, and that is, if Your Excellency finds for the claimant in this application, then the claimant seeks its costs to be assessed immediately and to be payable within 14 days on an indemnity basis, and statements of costs have been filed by both parties. And finally, Your Excellency, if this is the final sort of point at which I get to speak, then Your Excellency, may I foreshadow?
Have you put any reason for indemnity basis in your submission?
Your Excellency, I haven't, because I wanted to wait and see what my learned friend was going to say about this merits test. I was hoping to be inspired by something that my learned friend might say that would give rise to any sort of argument that there ought to be some criteria of merits tests. Your Excellency, we say that this case is taken out of the known because my learned friend has pointed to no authority whatsoever in the DIFC to even establish a basic threshold that the court should consider a merits test. There's simply nothing there. It is an unmeritorious application, even on the case that my learned friend relies on hard. Even in that case, it's a strikeout application after jurisdiction had been determined.
I'm telling you, it's not a weird application, but if there is any cost to be found in indemnity, where I'm sure we need to put the person who have to pay indemnity cost and give him some way to defend himself against indemnity in case of there is indemnity.
Your Excellency, I'm in your hands. It's at the last paragraph of my note. I leave it in your hands, Your Excellency. I'm not going to push it any further than that. You have my submission.
No, I will only comfort Mr. Sethi. There will not be any indemnity unless he replies to that, even if I find against him.
I'm grateful, Your Excellency.
Which I don't know what direction I'm taking now. Yes.
I appreciate that, Your Excellency. One final point now that I've got the floor.
Oh, this is the third final point, maybe.
Your Excellency, the only point that I wish to make is that at this sort of end of the screen, there will be a consideration of amending the pleadings in light of the evidence that's been put forward by actually, in fact, the defendant. And so therefore, I'm foreshadowing that if it comes to making any directions, and therefore, Your Excellency, when it comes to, if we get to that point, of course, it may be that Your Excellency decides that the claimant doesn't have jurisdiction. But if we get to that point, then any directions we would seek to confer with the defendant on those points.
But that's going to be a very tough one, Ms. Ahmed. I mean, this is it. It's a tough application. It's a tough application you're making now. It's.
No, I'm not making an application.
It's an application, a request, I would say.
No, I'm not even making a request. I'm not making a request. I'm simply saying, I'm foreshadowing that there may be an amendment to the pleadings, and if there is, then if there are any directions to be given or to be agreed, then that ought to be taken into account. There is no application before you, Your Excellency, and I apologise if I gave the impression that there was.
Okay, I consider there is nothing before me, and if there is anything you want to do, you can follow the rest of the procedures after that. Well, for now, I'm ready. I'm behind, Mr. Sethi. I would love to give you some rebattling, but we're behind. I have your submission. I have your written submission as well.
There is only one point I won't repeat this, and that is which hasn't been made, and that's in response to my learned friend's point on costs.
Yeah.
In this kind of application, Your Excellency, if you were to find against me and assume jurisdiction, the costs should be in the case. The reason for that is as follows. The claimant's evidence deals at length with the formation of an oral contract, and that evidence will be fundamental in the issues at trial, and the evidence given by the claimant here will be repetitive of the evidence that he will have to give at trial on those issues. In those, and he hasn't been cross-examined yet on those. That evidence is given as to an alleged contract. Now, in those circumstances, there are two reasons why the court should depart from the general rule of costs. The first is this: the claimant's costs of preparing for this hearing are in large part duplicative of the costs that would otherwise have to be incurred in preparing for trial. And the claimant's sworn written evidence on today's factual issues will be repeated in his evidence at trial. If he is granted costs of this application, then goes on at trial to lose, he will enjoy a net cost benefit. That would be unjust. The second ground is this: the evidence given by the claimant today is yet to be challenged under cross-examination at trial. It may not be accepted at trial, or it may even be found to be false at trial. In those circumstances, the proper order today is for costs in the case. It'll allow the court to assess the question of costs after it has had a proper opportunity to form a considered view about the nature of the evidence given by the parties. And it's for those reasons that we respectfully invite Your Excellency to order, if you were to find against me, that the costs of this interim application should be in the case. That is the course least likely to result in an injustice to the parties.
Alrighty, this is a bit, dramatic conversion of the events nowadays. Okay, so one was cost indemnity and straight away, and the other part is a case and cost in a case.
Yes,
we'll see. I mean, I would probably invite you to write something about in cost at the end of my decision. But I thank you for today's appearance. Thanks for your very clear pleadings and arguments. So I reserve for judgment. Thank you very much.